Morning. I'm Marc Garfinkle. I'm an attorney in New Jersey who handles, among other cases, juvenile cases, that is to say, cases arising in the juvenile courts. In New Jersey, the juvenile cases are handled in the family court division. This means that they're handled separate and apart from the criminal division, and so they're treated much differently. For example, a juvenile does not have the right to a trial by jury. A juvenile is going to get a trial, if at all, with a judge. And the most significant penalty that can be imposed on a juvenile being someone under 18 years of age, is 5 years in detention. Obviously, in Superior Court for adults, the most serious penalty is far, far greater. A juvenile case is adjudicated in the county where the juvenile lives, except under certain circumstances. Most other criminal cases are adjudicated in the county where the crime took place. And a juvenile detention, when a juvenile is taken into custody, that's considered a detention for the juvenile's protection. It is not an arrest. Juveniles are not arrested. They're detained for their own protection. Now, some cases involve such serious crimes, or they involve adult instrumentalities, such as automobiles, drugs, liquor, sex, that the juvenile may be waived up to Superior Court and tried like an adult. Now, one of the most important factors is how close to the age of 18 the juvenile is. The closer he or she is, the more likely the case will be waived up on the prosecutor's motion. Once in juvenile court, the case takes a pretty standard course. Generally speaking, the juvenile and his parents or her parents will get what's called a 5A letter. This is a letter saying to appear at the courthouse at such and such a date and time and apply for a public defender. This is because every juvenile must be represented by counsel. It's not like an adult who can waive his right to counsel. Generally, a juvenile will have to have a lawyer with him or her. When that notice is received, if the parents do retain private counsel, usually the juvenile must still appear because other processes such as intake or fingerprinting are usually arranged at the time of the 5A hearing, but that varies from county to county. One of the most important aspects of juvenile law is that the record tends to disappear, as we say, after the age of 18. This is not entirely true, and as every adult criminal knows, his or her juvenile record is always taken out at sentencing and discussed. But for the average person in the average circumstance, a juvenile record disappears when the juvenile reaches the age of 18, and he or she may not be asked questions about that except under very special and limited and clearly defined circumstances. If you have a juvenile case, or if you have questions about a juvenile case in New Jersey, and you would like to talk to me about that, please feel free to call. 973-275-1313 is the office number. My name again is Marc Garfinkle. Thank you, and have a good day.